Okay, so we've talked about some of the common error mistakes. Let's go to some more. So not including sufficient evidence of qualifications for a job. Another huge thing that I noticed, especially with LMI applications. Well, LMI work permits, people assume just because the LMI is there, they don't provide evidence. Or people just say, oh, here I have, I'm applying for an LMI exempt application as I don't know, this kind of position. And that's one of those positions where you have to show that you're qualified for the job. So you need to provide confirmation letters, you need to provide educational credential. If it's a licensed profession, you need to provide professional licensing, and measure when you should provide an English or a French test. Sometimes when we're doing managerial positions or executive positions and the person comes from a country that's not English or French speaking, I sometimes like to provide English and French tests for that. Some country specific checklist may ask for it. So obviously be careful about when you have to provide that. But again, this is very, very crucial. I see a lot of applications that you've gone through the difficult stages of the LMIA, or you've gotten the stuff and then you can't show that the person is qualified for the job. And I do it all the time. So even if I'm doing, let's say for instance, I'm doing like a Francophone work permit application. Technically, all you need to do there, other than the person having habitual language as French, you need to show that they're in a NOC 0A or B occupation. So there's no requirement there to provide employment confirmation letters showing that the person's qualified for that job, but I do anyway. If it's a supervisory position or a managerial position, I want to show that this person is qualified for that particular position. So even though the program does not require certain level of experience or certain years of experience, I want to show that my client is qualified for the job that's being offered. So if they're coming to a managerial position, I want to be able to provide evidence that they've been doing that job abroad. Same thing for, let's say, a NAFTA engineer. Well, if it's an entry-level position, then maybe you don't have to worry. But if it's manager, even though you don't have to provide evidence of work experience as a requirement for that kind of, for a NAFTA professional, for that kind of occupation, the officers are probably expecting to see it. And again, if it's a licensed profession, you need to provide evidence of that as well. Another common mistake that I see is people ignoring ties to home country. They just assume that, oh, we don't have to worry about that. We worry about that more in visitor applications, visitor visa applications, or study permit applications, and that's not really true. They are important in many cases, and you have to assess based on your client's immigration, family composition, their whole history, if they've had any refusals in the past, their assets. You want to make a decision and provide as much evidence to show that they have ties to another country. And things like the travel history, like so easy to document. You just have to include the whole passport, or even like the previous passport with all the pages that have stamps or marks, and sometimes people don't include them. And failing to declare immigration representative who assisted with their application. Again, sometimes you notice this. People sometimes have sometimes they have like people who are not authorized to do applications help them, and obviously that's a problem on its own. But sometimes people might consult someone. They might come to my office and say, like, I just have some questions about how to fill out these forms and how to do this. And I'm like, okay, it's a paid consultation. And if I find that I provide a lot of very specific advice and I'm actually like dictating to them how to prepare the cover letter, it's probably going to be pretty obvious that they had someone else that assist them with the application, maybe they prepared it themselves. So the way that I kind of like protect myself in those kind of situations is, you know what? Here's a use of rep form. I'm going to sign it. You can sign it and you can include it. And then you can say in your letter, during the preparation of this application, I consulted so-and-so, who's an immigration lawyer in Toronto. I don't wish this person to be my representative, and all correspondence should come to my address, but I'm including this use of rep form and disclosing this person for the sake of this full disclosure. And I think there's no harm in doing that. While they could get into trouble if they notice that this was prepared by someone else and they didn't declare it.